Be ready. Start. The respondents entered appearance and filed written statement denying the material allegations made in the plaint. Leaving aside the other facts in the present case, we may state here that a specific defense taken by the respondents in their written statement was to the effect that the suit was barred by limitation in view of Article 58 of the Act because the suit having been filed after about 18 years of entering into the compromise by the parties in the High Court in the latter's patent appeal must be filed within 3 years from the date of entering into the alleged compromise by the parties. Accordingly, the respondents alleged that the suit must be dismissed on the ground of limitation. We make it clear that since the only question involved in this appeal is relating to the question of limitation, we have not considered the other aspects of the matter in this judgment. After the parties had entered appearance and led evidence in support of their respective cases, also on the point of limitation, the trial court held inter alia that the suit was barred by limitation in view of Article 58 of the Act as the cause of action arose on the date of compromise entered into by the parties. Feeling aggrieved, the appellants filed an appeal before the Additional District Judge Kanpur, who also dismissed the file of the appellants inter alia, holding that the suit was barred by limitation. Consequent thereupon, the appellants approached the High Court in second appeal, and the High Court also dismissed the appeal, holding that under Article 58 of the Act, a declaratory suit must be filed within 3 years of arising the cause of action for filing the suit. The High Court held in the impugned judgment that the cause of action arose when the parties had entered into the compromise, and therefore the suit having been filed on 21st of August 1990 was barred by time, since it was filed after 18 years from the date of the said compromise. As noted herein earlier, the only question therefore to be decided is whether the mere existence of an adverse entry in the revenue records had given rise to cause of action as contemplated under Article 58, or it had accrued when the right was infringed or threatened to be infringed. Let us therefore consider whether the suit was barred by limitation in view of Article 58 of the Act in the background of the facts stated in the plaint itself. Article 58 of the Act clearly says that to obtain any other declaration, the limitation would be 3 years from the date when the right to sue first accrues. In support of the contention that the suit was filed within the period of limitation, the learned senior counsel appearing for the appellants before us submitted that there could be no right to sue until there is an accrual of the right asserted in the suit, and its infringement or at least a clear and unequivocal threat to infringe that right by the defendant against whom the suit is instituted. Mr. K. M. Sinha, learned senior counsel appearing for the appellant, submitted that this court has held that the beneficial provisions of the Act are to be applied only for the purpose of interpretation of the Act and not for arriving at a conclusion whether a person is juvenile or not, and the question whether an offender was juvenile on the date of commission of the offense or not is essentially a question of fact which is required to be determined on the basis of the materials brought on record by the parties. He submitted that this court has further held that Section 35 of the Evidence Act, which provides that an entry in a register maintained in the ordinary course of business by a public servant in discharge of his official duty or by any other person in performance of a duty specially enjoined by the law of the country will only apply if the conditions mentioned in Section 35 are fulfilled. He submitted that Section 35 of the Evidence Act could not be applied to the entry of date of birth of respondent number 1 in the school records produced on behalf of respondent number 1 before the trial court, and on the evidence as produced, the trial court rightly held that the date of birth of the respondent number 1 cannot be believed to be 5/10/1988. He submitted that the trial court, after scrutinizing the evidence, has held that the evidence produced by respondent number 1 have been created for escaping conviction for a grave offense such as murder and was not believable, and by physical appearance respondent number 1 looks to be over 18 years of age, and on 11/7/2004 he was an adult and not a juvenile. He submitted that this finding of the trial court on a question of fact with regard to the age of respondent number 1 could not be disturbed by the High Court in a revision. In support of this proposition, he relied on Sitamani Rao versus State of UP bracket 1986 for SCC 447, in which this court has held that the High Court, while exercising its jurisdiction under Articles 226 and 227 of the Constitution, should not interfere with a finding of fact of the inferior court or tribunal except where the finding was perverse and not based on any material evidence or has resulted in manifest injustice. He submitted that in this decision, this court has further taken the view that if the trial court came to a conclusion which was possible on the evidence, the High Court will not disturb the conclusion arrived at by the trial court merely because the High Court is of the view that a different conclusion is also possible on the same evidence. He vehemently argued that the High Court has lost sight of these limitations of its jurisdiction, and on the basis of its on appraisal of the evidence taken a view that the respondent number 1 was a juvenile on the date of the commission of the offence and has set aside the order of the trial court.